Hello dear students, welcome back to the class Taxation Laws of Bangladesh. This would be class number 6 if I am not wrong, and class number 6 video 1. We are almost approaching close to the subject income tax ordinance direct tax. So today we will be discussing dispute resolution. We'll be discussing dispute resolution. As you know that in ordinary court, parties file suits and those are disposed of by the courts and disputes are being settled. In income tax law, there is also provisions for dispute settlement. What is the dispute? Dispute means that whenever the Deputy Commissioner of Taxes makes the assessment or imposes tax, the taxpayer might not like it. She might feel aggrieved at the assessment order made by the Deputy Commissioner of Taxes. Let me tell you one thing, that the job or the function disposed of by the Deputy Commissioner of Taxes is not 100% judicial, but that is quasi-judicial. So again, the job or the judgments or the orders passed by the income tax department, they are not judicial, 100% judicial, but they are quasi-judicial, like judicial, because against those orders, the taxpayer can file appeal. The taxpayer can go up to the appellate division of the Supreme Court of Bangladesh, the highest forum for settling disputes among the parties on certain circumstances, under certain circumstances, on certain matters. So, if the Deputy Commissioner of Taxes makes the assessment, then if you are aggrieved, it means that you are not satisfied with the judgment or the order passed by the Deputy Commissioner of Taxes, then you probably you'd like to prefer you would like to the matters to be settled by any other higher forum than the Deputy Commissioner of Taxes. So here the question of appeal comes. So the as a matter of law, this is a right that if there is the assessment made by the Deputy Commissioner of Taxes, then you are not satisfied with the judgment of the Deputy Commissioner of Taxes, then you can go for appeal. Now, appeal, you can go for the settlement of disputes in two forms. One is the alternative dispute resolution system, another is the normal or traditional dispute resolution forum, that is appeal, first appeal, second appeal, third appeal, etc., and until finally to the High Court Division or the Appellate Division of the Supreme Court of Bangladesh. So two forums. One is the alternative dispute resolution forum, another is the traditional dispute resolution forum. Now, alternative dispute resolution, before in the income tax ordinance there was no provisions of alternative dispute resolutions, but in 2011 the provision of alternative dispute resolution system was introduced in Bangladesh through insertion of Chapter 18 capital B. Again, through insertion of Chapter 18 capital B in the income tax ordinance, which says alternative dispute resolution. Alternative dispute resolution means that without going to the traditional dispute resolution forum, if the parties prefer to settle the dispute in a summary manner or in the quickest manner, then the taxpayers can go for the alternative dispute resolution. This is a new concept, comparatively new concept, yet to be burgeoned or yet to be developed in the income tax department. But however, the system is there, and we have to go through the system, the procedures of how to go to the alternative dispute resolution forum to file appeal and to settle the dispute. Now, as I told you, Chapter 18B, capital B, deals with the alternative dispute resolution, and Chapter 19. Chapter 19 deals with appeal and reference. Chapter 19 deals with appeal and reference. So we'll be covering these two issues today in this video 1, lecture 6, alternative dispute resolution and appeal and reference. Chapter 18 capital B and chapter 19 of the Income Tax Ordinance 2024. Now, first of all, chapter 18B, alternative dispute resolution. Now, in chapter 18B, capital B, sections are inserted like section 152F, capital F2, section 152S. So it starts from section 152, capital F2, and it ends at section 152, capital S. So one section having a lot of subsections: F, G, H, I, J, K, L, M, N, O, P, Q, R, S, T. So first of all, let's discuss briefly alternative dispute resolution procedure and systems. Alternative, as you know, that alternative means that alternative which is alternative to the traditional dispute resolution forms. Now, why people, or why the taxpayers, why the parties should prefer alternative dispute resolution? What are the causes? The causes are manifold for opting for alternative dispute resolution. For example, in alternative dispute resolution, you can settle the dispute within time, less cost, and in a very homely environment. On the other hand, the traditional dispute resolution form, the most important thing, it takes time and it takes money, and in some cases you cannot afford time. So in that case, alternative dispute resolution is better. For example, arbitration. You know that there is arbitration system in our country and there is arbitration law. Big disputes, commercial disputes involving millions and billions of taka, the parties prefer arbitration because arbitration process quickly disposes of the matter and saves the parties money and time. So, in the same line, in the same vein, the provisions of alternative dispute resolution was introduced in the Income Tax Ordinance 1994, chapter 18, capital B, section 152F says alternative dispute resolution. It says that notwithstanding anything contained in chapter 19. Chapter 19 means appeal and reference, traditional dispute resolution system. So notwithstanding anything contained in chapter 19, any dispute of an SSC, means the taxpayer, lying with any income tax authority, taxes appellate tribunal or court, may be resolved through alternative dispute resolution in the manner described in the following sections of this chapter and rules made thereunder. Board may, by notification in the official gazette, specify the class or classes of SSC eligible for adhere or extend the area or areas in which these provisions may be applied. So, taxpayers can prefer appeal despite the fact that the case is lying with the income tax authority or the taxes appellate tribunal. Taxes appellate tribunal is get a traditional higher form than the first appeal. A second appeal is being preferred to the taxes appellate tribunal. We'll be discussing shortly when we go to section chapter 19. Dispute here means that income tax dispute here means that according to section 152H, dispute means an objection of an assessor regarding assessment of income above the income declared by him in his return of income for the relevant year, or order of the appellate authority under chapter 19 which results in assessment of income which is above the declared amount on his return of income. So this is pretty simple. If the taxpayer is not happy with the order of the income tax authority, then she can go to the alternative dispute resolution. That if he makes objection to the order, that means refers to the dispute. Application, section 152I, capital I, application for alternative dispute resolution. If aggrieved by the order, an aggrieved person by an order of the income tax authority may apply for resolution of the dispute through the ADR process. ADR means alternative dispute. This is not mandatory. The taxpayer can, if he chooses, he may apply for his case to be settled by the ADR process. Uh, Income tax authority should give permission for the disposal by the ADR system. Now, what are the systems for filing application to the ADR authority? Now, let me tell you briefly. The National Board of Revenue gives appointment to some facilitators. So, alternative dispute resolution under the income tax ordinance is like sort of negotiation between the parties. So the income tax department is one party and the taxpayer is another party. So if there is any dispute, they negotiate between themselves. To oversee the negotiation, whether the negotiation is going on well, there is one facilitator, or you can say mediator. In international law, you'll find settlement of disputes, arbitration, mediation, etc., etc. So there are dispute settlement process, arbitration, mediation, and others. So reconciliation, something like that. So in income tax ordinance, if there is a dispute, then two parties, one is the income tax department, another is the taxpayer. They sit together under the mediation or facilitation of a facilitator, who interferes or who oversees the negotiation between the department and the taxpayer. And after discussion or negotiation, the parties come to a decision, and that decision is binding on both the parties. And the facilitator who mediates or who works as a facilitator, he just writes down the negotiation and writes down the judgment that on which both the parties agreed. And then it is disposed. The case is disposed of. The order is disposed to both the taxpayer and the income tax authority. So that is the binding. That's how within a short period of time the tax dispute is settled by the income tax alternative dispute resolution system. Now there are some other small points. The application for ADR shall be submitted in such form within such time, accompanied with such fees and verified in such manner as may be prescribed. The application may also be filed in such electronic, computer readable or machine readable form and in such manner as may be prescribed by the board. So National Board of Revenue is the highest authority to decide how the ADR application should be made. Eligibility for application for ADR, section 152 capital J. An SSC shall not be eligible for application to ADR if he fails to pay tax payable under section 74 for the return of income for the relevant year or year has been submitted. So the taxpayer, if he wants to make an application to the ADR, then he has to pay the tax on the basis of the return. It means that what he thinks that his tax liability should be. If he says that yes, my tax liability should be 100 taka, then before filing application to the ADR, he must pay that 100 taka to the government treasury. After that, a facilitator is appointed by the National Board of Revenue. As I told you earlier, the facilitator just facilitates decision of the ADR. A dispute which is subject to this ordinance may be resolved by an agreement, either wholly or in part, where both the parties of the dispute accept the points for determination of the facts or laws applicable in the dispute. Where an agreement is reached, either wholly or in part, between the SSC and the Commissioner's representative, the facilitator shall record in writing for details of the agreement in the manner as may be prescribed. The recording of every such agreement shall describe the terms of the agreement, including any tax payable or refundable and any other necessary and appropriate matters. All the details will be recorded in the order of the facilitator. Now, if you go for the ADR, Alternative Dispute Resolution, section 152Q says, limitation for appeal where agreement is not concluded. Notwithstanding anything contained in any provision of the ordinance or an agreement is not reached under this chapter, it means that the department and the parties cannot reach any agreement under the ADR system. Only one part, the SSC may prefer an appeal to the Appellate Joint Commissioner of Taxes or Appellate Additional Commissioner of Taxes. So, the taxpayer can go for the traditional. If there is no agreement, the taxpayer can go for the traditional dispute resolution mechanism under Chapter 19 of the Income Tax Ordinance. So that's the after the order is passed, the facilitator will mention a time within which the tax to be paid by the taxpayer. Then if the taxpayer doesn't pay the tax within time, then the order will not be effective or valid. So that's the alternative dispute resolution system under Chapter 18 capital B. Now that was the alternative dispute resolution. Now we'll go for the traditional dispute resolution from appeal and reference. Section Chapter 19 appeal and reference, Section 153 of the Income Tax Ordinance says that appeal against the order of the Deputy Commissioner of Taxes and inspecting Joint Commissioner of Taxes. Any SSC not being a company aggrieved by any order of the Deputy Commissioner of Taxes in respect of the following may prefer an appeal to the Appellate Joint Commissioner against such order, namely the amount of loss computed under Section 37, the assessment of income, determination of liability to pay or computation of tax including advance tax, imposition of an interest under Chapter 7. Chapter 7 means, Chapter 7 is the deduction of tax resource. Imposition of penalty under Chapter 20, under Chapter 12A, Chapter 15, and under Section 137 of Chapter 16, and refusal to allow a claim of refund, etc., etc. So there are provisions that you can file appeal to the Appellate Joint Commissioner of Taxes if you are not a corporate taxpayer, if you are not a company, if you are an individual taxpayer, you can file appeal to the Appellate Joint Commissioner of Taxes. Now it says that 153(1) says any SSC being a company aggrieved by an order of a Deputy Commissioner of Taxes or an SSC aggrieved by an inspecting Joint Commissioner of Taxes may file appeal to the Commissioner of Appeals. Now, so two things. In case of traditional filing of traditional appeal, if you are not a company, then you file appeal. Note well, if you are not a company but an individual taxpayer, you file appeal with the Appellate Joint Commissioner of Taxes. Now, if you are not an individual but you are a company taxpayer, then you file appeal with the Commissioner of Taxes Appeals. So again, individual appeal to Joint Commissioner of Taxes, company appeal to the Commissioner of Taxes within parenthesis appeals. Okay, so once you file appeal, then you must file appeal in the prescribed form, and you have to pay a fee to the government treasury to file appeal. Say 400 taka, you must pay as fees to the government treasury before file appeal. And there is prescribed form. Prescribed form is found in Part 2, Income Tax Manual Part 2 rules. You'll find the income tax form. So once you decide to file appeal, traditional appeal, you can file appeal to the Appellate Joint Commissioner of Taxes or the Commissioner of Taxes appeal, and you file the appeal in the prescribed form, giving the fees to the requisite fees to the. Now, the law says that no appeal shall lie against any order of assessment under this section unless tax payable on the basis of return under Section 74 has been paid before filing that appeal. So, in the alternative dispute resolution form, you also notice that if you want to file an appeal or application with the idea, you have to pay tax on the basis of the return. That is the admitted liability. So here again, if you want to file a traditional appeal, then the law says that yes, you have to pay tax before filing the appeal. No appeal shall lie against any order of the assessment under this section unless the assessee has paid 10% of the tax as determined by the Deputy Commissioner of Taxes, where return of income was not filed in accordance with the provisions of this ordinance. So again, it says that 10% under certain circumstances you have to pay 10% tax to the government treasury for appeal. Section 154 says form of appeal and limitation. Every appeal under section 153 shall be drawn up in such form and verified in such manner as may be prescribed, and shall be accompanied by a fee of 200 taka. So before it was 100 taka, now it's 200 taka fee. The board may, by notification in the official gazette, specify the cases in which appeal shall be filed electronically or in any other manner, machine readable or computer readable media. Specify the form and manner in which the appeal shall. So the board, National Board of Revenue, will specify everything regarding the filing of application forms, written, electronic, or whatever. The Appellate Joint Commissioner of Taxes or the Commissioner of Appeals, when you file appeal, the question, when you file appeal with the Commissioner of Taxes Appeals, please note that. You can gather that from the lecture I told you earlier. The Appellate Joint Commissioner or the Commissioner of Appeals, as the case may be, may admit an appeal after the expiration of the period of limitation specified in subsection 2. And so you have to pay, you have to submit the return within time. So what is the time limit for filing such appeal to the appellate authority? Subject to such subject to subsection 3, an appeal shall be presented within 45 days if it relates to the assessment or penalty from the date of service of notice of demand relating to the assessment or penalty, as the case may be. So again, so you must file appeal within 45 days of service of the order. In any other case, from the date on which the intimation of the order to be appealed against the SAP. So this is pretty much like the civil procedure, where you'll find detailed rules regarding filing of time of filing of appeal and service of notice. Basically, service of notice in the CPC you'll find. So rule 5 or 6. So you have to file appeal within 45 days of the service of the order. The day you receive, the limitation period starts counting from the day. Now, section 155 says procedure of appeal before the Appellate Joint Commissioner of Taxes. The time limit can be counted as I told you earlier. Subsection 3 said that the time limit for filing appeal 45 days may be counted by the tax authorities, by the appellate authorities in appropriate cases. Now, section 155 deals with the procedure in appeal before the Appellate Joint Commissioner of Taxes. The Appellate Joint Commissioner of Taxes or Commissioner of Appeals shall fix a day and place for the hearing of the appeal and give notice thereof to the appellant and the Deputy Commissioner of Taxes against whose order appeal has been brought. So once you submit your appeal, then notice is being issued to you as a party and to the respondent, the department, and then the appellate authority fixes the date of hearing, and after it takes hearing, then it disposes of the appeal. It can demand papers, documentations, evidences from the taxpayer, and he can take explanation from the department. That's the basic substance of section 154. Please go to. And now 156 says decision by appeal or appeal by Appellate Joint Commissioner or Commissioner of Appeals. In disposing of an appeal, the Appellate Joint Commissioner or the Commissioner of Appeals may, in the case of an order of assessment, confirm, reduce, enhance, set aside, or annul the assessment. So, if there is any assessment against which you prefer an appeal, then what the appellate authority can do, it can confirm the assessment, reduce the assessment, enhance the assessment, set aside the assessment, or annul the assessment. In case of an order imposing a penalty, confirm, set aside, or cancel such order or vary it, so either to enhance or to reduce the penalty. In another cases, pass such order as it thinks fit. The Appellate Joint Commissioner shall not enhance an assessment or penalty or reduce the amount of refund unless the appellant has been given and reasonable opportunity of showing cause against such enhancement of attack. So there is a universal rule or the all-term partem that the party, before you dispose of the case, before you pass your verdict, then the parties must be heard. That's the natural rule of law that is known as the OD all-term partem. Perhaps you are very much aware of that rule. So what the appellate authority will do under section 156, then enhance, etc., whatever, then the parties must be given an opportunity of being heard. That is OD all-term partem. Without that, the case cannot be disposed of. So that's the procedures of a decision of appeal by the Commissioner, Appellate Joint Commissioner of Tax or Commissioner of Tax Appeals. On the disposal of appeal, the Appellate Joint Commissioner or the Commissioner of Appeal shall communicate the order passed by him to the Deputy Commissioner of Taxes and the Commissioner within 30 days. So whenever the appellate authority makes any order or passes an order, then that must be communicated within 30 days, both to the tax clerk and the department. Now, Section 158 says that appeal to the appellate tribunal. Now, the appeal, please note well, the appeal you file with the Appellate Joint Commissioner of Taxes or the Commissioner of Taxes Appeals, and that is the first appeal, the first traditional appellate forum. So that's we can call it a first appeal. So if you are not happy with the decision of the first appeal, naturally you might not be happy with the decision of the first appellate authority, then you can go for second appeal. Again, if you are not happy with the decision of the first appellate authority, then you can go for the second appeal. Now, to whom you go for the second appeal? You file an application for second appeal to the Taxes Appellate Tribunal. So again, I tell you, if you are not happy with the order of the first appellate authority, Appellate Joint Commissioner of Taxes or Appellate Commissioner of Taxes or Commissioner of Taxes Appeals, then you file second appeal to the Taxes Appellate Tribunal under Section 158 of the Income Tax Ordinance. Now, it says, 158 says, an assessee may appeal to the Appellate Tribunal if he is aggrieved by an order of an Appellate Joint Commissioner or the Commissioner of Appeals, as the case may be. So, second appeal can be light or application can be made for second appeal to the Taxes Appellate Tribunal. No appeal under subsection 1 shall lie against an order of the Appellate Joint Commissioner or the Commissioner of Appeals, as the case may be, unless the assessee has paid 10% of the amount representing the difference between the tax as determined on the basis of the order of the Appellate Joint Commissioner of Taxes or the Commissioner of Taxes. So, if you want to prefer second appeal, then you have to pay 10% of the disputed tax to the government authority. If you don't pay 10% tax of the disputed amount, then you cannot file second appeal to the Tax Appellate Tribunal, provided that on an application made in this behalf by the assessee, the Commissioner of Taxes may reduce the requirement of such payment if the grounds of such application appears reasonable to him. So, you want to get exemption from payment of 10% tax, then you can make the application to the concerned Income Tax Commissioner. Then if the Commissioner thinks that yes, you are eligible to get exemption, then he can give you exemption under subsection 2 proviso of Section 158. The Deputy Commissioner of Taxes may, with the prior approval of the Commissioner of Taxes, prefer an appeal to the Appellate Tribunal against the order of an Appellate Joint Commissioner or Commissioner of Taxes. So second appeal can be filed again. A second appeal can be filed both by the Deputy Commissioner of Taxes or by the party, by the taxpayer, because whenever the first appellate authority passes an order, the Income Tax Department might be equipped at the order. So there is provision that the Income Tax Department, the Deputy Commissioner of Taxes, can file appeal. Now, sorry. Now, every appeal under subsection 1, so second appeal, if you decide to file second appeal, then what should you do? Every appeal under subsection 1 or subsection 2A, it means that which provides for the provision of filing second appeal. The application shall be filed within 60 days of the date on which the order sought to be appealed against is communicated to the SSC or the commissioner as the case may. So that's basically the time limit, that within 60 days of the service of the assessment order, you should file second appeal to the appellate tribunal, provided that the appellate tribunal may admit an appeal after the expiry of 60 days if it is satisfied that there was sufficient cause for not presenting the appeal within that period. So if the tribunal thinks that there was enough reason not to present the second appeal in time, then the tribunal may condone the time limitations. The department usually fails to file appeal within the time, so in most cases the department files application with a condonation petition to condone the time that second appeal has not been filed within time. An appeal to the appellate tribunal shall be in such form and verified in such manner as may be prescribed, and shall, except in the cases of an appeal under subsection 2A, be accompanied by fee of 1,000. So 1,000 fee should be given. The board may, by notification in the Gazette, specify the cases in which appeal shall be filed electronically or other. So it says basically that you can file appeal electronically to the second appellate authority, but provided that the National Board of Revenue (NBR) will specify the cases in which you can file electronic application. Section 159 says disposal of appeal by the appellate tribunal. The appellate tribunal may, after giving both the parties to the appeal an opportunity of being heard, pass such order on the appeal as it thinks fit. Before disposing of appeal, the appellate tribunal may call for such particulars as it may require respecting the matters arising in the appeal or cause further inquiry to be made, etc. by the Deputy Commissioner of Taxes. The appellate tribunal shall communicate its order on the appeal to the SSC and to the Commissioner within 30 days from the order. So when the tribunal makes order, then that must be communicated to the SSC and the department within 30 days. So that's the second appeal. Now, second appeal to whom? First appeal, again, if I sum up, first appeal to the Appellate Joint Commissioner of Taxes if you are individual taxpayer, then Commissioner of Taxes appeals if you are corporate taxpayer. If you are not happy with the first appellate authority, you file second appeal to the Taxes Appellate Tribunal. So far I have discussed the provisions. Now, Section 160 says reference to the High Court Division. Reference to the High Court Division. Please note well, listen to my lecture carefully at this part. When you file second appeal to the Taxes Appellate Tribunal, then tribunal passes its judgment. It gives its judgment. So it can pass its judgments on two issues. In every case, there are two things. One is the question of two questions. One is question of law, one is question of fact. Again, in every case, there are two questions. One is question of fact and another is question of law. So in case of question of fact, the judgment or decision of the Taxes Appellate Tribunal is final. You cannot go for further appeal to the High Court Division against that order, because that's a matter of fact and that is the final. In the High Court Division, in Elite Chemical Company Limited versus Commissioner of Taxes Appeal Zone 3, decided that the judgment passed by the Taxes Appellate Tribunal in question of fact is final and no appeal lies to the High Court Division of the Supreme Court of Bangladesh. So if it is a question of fact, it's a matter of fact, the decision of the Appellate Tribunal is final. But if there is any question of law, only then you can file reference application to the High Court Division. Again, if there is any question of law, only then you can file appeal to the High Court Division. It says that Section 160 refers to the High Court Division. The assessee of the Commissioner may, within 90 days from the date of receipt of order of the Appellate Tribunal communicated to him under Section 159 by application in the prescribed form, accompanied in the case of application by the assessee by a fee of 2,000 taka, refer to the High Court Division any question of law arising out of such order. So 160 says clearly that any question of law arising out of such order, provided that no reference under subsection 1 shall lie against the order of the Taxes Appellate Tribunal unless the assessee has paid the following taxes at the rate of 15% tax difference must be paid. Also, so it says that you must pay the disputed amount of tax. A certain percentage of disputed, it is 15% and 25%. So you have to pay that tax if you want to go to the Appellate Division or High Court Division of the Supreme Court of Bangladesh for any matter that involves question of law. An application under subsection 1 shall be in triplets and shall be accompanied by the following documents, namely certified copy, etc. So the filing of reference application to the High Court Division is like the Civil Procedure Code and the requirements as in the normal ordinary cases. So please check all those things, and section 160 that the certified copies and other things on papers should be attached before filing an reference application with the High Court Division of the Supreme Court of Bangladesh. Where any case has been referred to the High Court Division, 160, section 161, where any case has been referred to the High Court Division under section 160, it shall be heard by a bench of not less than 2 judges. The division bench will hear the case. It shall be heard by not less than 2 judges, and the provisions of section 98 of the Code of Civil Procedure 1908 shall, so far as may be, apply in respect of such case. The High Court Division shall, upon hearing any case referred to it under section 160, decide the question of law raised therein, and shall deliver a judgment thereon, stating the grounds on which such decision is founded, and shall send a copy of such judgment under the seal of the court and signature of the registrar to the Appellate Tribunal, etc., etc. So the High Court Division will pass its order and then communicate to the respective persons, to the department and the taxpayer. So that's the thing that that's the discussion for today. There is a settlement of income tax disputes through alternative dispute resolution system and through traditional dispute resolution forum like First Appellate Authority, Second Appellate Authority, and the High Court Division. And another thing is that if there is if the party is not happy with the judgment of the High Court Division regarding the question of law, then the case second appeal can be filed further to the Appellate Division of the Supreme Court of Bangladesh, for which leave of application petition must be submitted with the court. So that's all for the income tax dispute resolution system. So please go through well. I'll be back with you in class 7 with some other fascinating issues of the direct taxes, income tax issues. Until then, take care, goodbye. And in the consultation class, if there is any points not clear or anything, any issues to be discussed, we'll discuss in the consultation class. Until then, take care, goodbye, Allah Hafiz.